Good morning and welcome to the Aird Berlis LLP webinar series. Today's topic is the modern workplace, managing to succeed, a clever title. And today I'm joined by my colleagues, Mike Horvat, Fiona Brown, and Megan Cowan. And we are going to take you through some of the topics that we get a lot of questions on a day-to-day basis from our clients, and which we thought would be a good idea to address. Some of them we've heard of before, but putting them together in terms of the management of the workplace seemed to make sense to us, and based on the numbers of people who are joining us this morning, I think it makes sense to you as well. So thank you for joining us. We're going to get right to this, and we do have some questions, but we encourage you to send more questions in, and we'll get to what we can. So here's what we're going to do today. We're going to talk about family status. Talk about it as the sandwich generation, and that means that you've got people who have both child rearing and child care responsibilities often, as well as elder care responsibilities. This is a tough thing, and employers are struggling with it as well in terms of how to manage both absences and accommodation. We're going to look at privacy considerations in the workplace with social media. We're going to revisit that. We also get a lot of questions on a day-to-day basis on departing employees and how you make sure that they don't do damage to your business. We'll revisit gender issues and harassment because, again, that has been a prominent issue amongst employers, and explore a little bit about alternative work arrangements and how employers can meet the requests of their employees sometimes in terms of working from home or alternative arrangements. So first, let's talk about family accommodation. So we talk about the sandwich generation, as I said, and it is a real concern, and I'm going to go to a Globe and Mail article in a second, but if you look at the Statistics Canada projection that 1 in 5 Canadians will be 65 or older, you do understand that there's going to be a lot of people who are going to be responsible for elder care. I was at a function on Saturday, and I saw a couple I hadn't seen in a long time, and I said, "How are you doing?" They said, "Well, we basically have 4 parents now that we're taking care of." And, you know, the younger professionals, but still caught with kids and caught with older parents. Yesterday in the Globe and Mail, there was an article just on this topic, and the statistics are not very new. The most recent ones we have are from 2015. But if you look at it, and I would encourage you to take a look at that article because it's quite illuminating in terms of what employees are going through. 2012 report, and I'm sure that it's much more prevalent right now. 60% were working at a paid job or business, and these are caregivers. So there was a specific Statistics Canada report on dealing with caregivers. 28% had children under the age of 18. Parents were often the recipients of caregiving activities. About 50% of them reported caring for their own parents or parents-in-law over the past year. Now, you can relate with that, I'm sure, as you sit and listen to this webinar. 43% of the employees arrived to work late or had to leave early, and 15% slashed their weekly hours, and 10% passed up a promotion or a new job. And that is really relevant because what we see in the anecdotal evidence is that people are saying, "I've had to give up job opportunities because I simply can't put in the amount of work necessary for me to kind of devote to career advancement," so they actually take a step back. And that's a real concern for reasons we'll talk about in a little bit for employers. I'm going to ask Michael to kind of take us into the general law of family status and accommodation, and then we'll talk about how we can apply it to your workplace. Michael?
Thank you, Lorenzo. So let's start with the definition of what is family status under the Human Rights Code. And the Human Rights Code identifies 2 different sets of relationships, one being marital status and the other being family status. Let's speak briefly about marital status. On its face, it's pretty easy to identify someone who is married. Now, it also includes persons who are married, single, widowed, divorced, or separated, and who are living in a conjugal relationship even outside of marriage. Of course, it includes persons of the same sex or opposite sex relationships. Where the line and where it gets fuzzy is in respect of roommates, people who maybe are living together out of both an economic need, but more appropriately an emotional need. And often employers are put to the test and don't even want to ask the question as to whether that relationship is conjugal or not, and to trip them into a marital status. So oftentimes you will see individuals who are older, who may be living together for that emotional and economic support, who are treated as being married and therefore should be accorded the same protections as a married couple. Family status is that of being a parent or a child, and this is a sort of an embodiment of the sandwich generation. You can be both a parent and a child at the same time and have obligations that move up and down in the family status and the family cycle situation. So when it comes to what accommodation is needed to be afforded, some guidelines have been provided by the courts with respect to parental obligations. So clearly, in order to have a parental obligation, you have to be a parent and you have to be responsible for the child's care. It's not that you have to be in a permanent child care relationship. Clearly, separated or divorced parents are going to have equal, who have a custody child sharing arrangement, are each going to have separate child care obligations throughout, even though they're carried on at separate locations or separate houses. It is a legal obligation that must be afforded. This is interesting because oftentimes the legal obligation blends into options that are required for the child's care itself. So we're not talking about personal family choice here. You want to be at the practice or the recital. However, in situations such as a medical need where the practice or the recital is either for a physical rehabilitation or provides mental stability for the child, that can switch into a legal obligation such that it has to be accommodated. As we're going to go through the case law, it's really important to remember that the employee as well as the employer must show that they've made reasonable efforts to try other alternatives with respect to child care or parental care, elder care situation before they get into the more full-blown accommodation review. They need to come and consider and provide you opportunity to consider alternatives and to show that they've at least stepped up to the plate. And then they've got to demonstrate that there's been a real interference. Again, it's not a personal choice. Getting off at 5 o'clock may require them to skip dinner to go to the recital, but that's not a real interference with their life situation, as it may be if staying until 5 o'clock on a mere policy basis actually prevents them from actually attending. And so with respect to some of the recent cases, Fiona's going to take us through the Linklater decision, which is a really interesting case.
Thanks,
Fiona?
Michael. Yeah, so this Linklater and SR Steel Goma Inc. is a very positive employer decision. In this case, the employee worked a continental shift schedule, so 4 days at work followed by 4 days off when he was injured in a workplace accident. The employee was accommodated in a temporary position within his physical restrictions, but required a change in position and a change to straight 5-day shift, which also resulted in less net pay, as he was no longer receiving the night shift premium. The employee had joint custody of a child following a separation and had an access schedule set by a court which was structured around his prior continental shift schedule. The employee alleged his reduction in pay was the result of discrimination in accommodation and family status. The company was eventually made aware of the custody order, triggering the duty to accommodate, but the employee failed to participate in meetings or advise of the conflict in scheduling. So no change was made to the accommodation provided. The tribunal ultimately dismissed the complaint. The fact that the employee had failed to pursue the process of accommodation review under the collective agreement likely contributed to the lack of information exchange between the parties. The tribunal had accepted the supervisor's comments at the hearing that in the event the employee had made him aware of the issue earlier, he would have certainly explored it and accommodated him. Employers can only act and accommodate on what is disclosed. That said, we still encourage our employer clients to make inquiries when considering accommodation options. So in this case, the employee had taken a singular position that the only accommodation that would work for him was being put back on a 12-hour shift, as that's what his custody order was based upon. The employee would simply not review or even accept alternatives or take steps to determine why the proposed accommodation did not work. This case is a positive reminder for employers that accommodation is not about employee preferences, and an employer can certainly focus on options that have the least undue interference in their operations, yet still meet the employee's restrictions. This case can also serve as a positive reminder that accommodation can be compensated for the accommodated work actually performed. There is no obligation to top up or red circle accommodation.
So it's interesting because before Megan gets into the Mystic case, that in many of these cases, what we're seeing is if the employee had been smart about this, or the union had been smart about it, it would have been a completely different result. And what we're seeing is there's a real stubbornness on employees who read about family status accommodation and say, this is what I need, this is what you have to do, and they won't relent. And surprisingly, unions take that position as well because they're terrified of getting a human rights complaint filed against them. So what we're seeing is where employers take a reasonable approach, ask the right questions, get the right information, and come up with a reasonable alternative, they're the ones who are in the better position. And this is going to be born in the Mystic case. Megan?
Thanks, Lorenzo. Yeah, this case definitely follows in the lines that you just mentioned. It's a 2016 decision from the Ontario Human Rights Tribunal, and it is a really good decision for employers because it looks at and provides clarity on what kind of accommodation should be provided in elder care situations. So this case involved a dispute with an employee. She alleged that a proposed change to her work schedule in order to accommodate her physical restrictions actually discriminated against her on the basis of her elder care responsibilities. So specifically that she needed to be home to prepare dinner for her elderly mother. So it's almost, two levels of accommodation. One, the company's accommodating her physical restriction, and what was proposed, she alleged, violated against, her rights in terms of her elder care obligations. So at the tribunal, the tribunal provided some interesting commentary and analysis with respect to elder care situations specifically. It held that an analysis for evaluating discrimination claims is the same as any other protected ground. The applicant must establish that she's part of a protected group and that she was discriminated against on that basis. So there's some commentary slightly on the Johnson test that Michael already went through, but Johnson case had suggested that a parent must have a legal obligation towards a child. In this case, the tribunal provided some clarity to that in terms of an elder care relationship. Obviously, a child may not have a legal responsibility to their parent, but it's still recognized under the grounds of the code. And so because of this, when looking at the situation in the facts of this case, the tribunal dismissed the application because the employee had really failed to provide any kind of appropriate documentation to establish those responsibilities. The tribunal noted the employee was able to provide lunch to her mother away from the office, so they failed to see her argument on the elder care. So another good case for employers, and it shows you the need to engage in reasonable accommodation efforts.
Great, thanks, Megan. So what do you need to know? Well, you need to know this. First, that this area of the law is in flux. There are the goalposts are somewhat changing, but I wouldn't say that the law itself is changing, but the interpretation is changing as we get through specific fact situations where employers and employees, and often unions, and sometimes even involving doctors, have to figure out exactly how all of this works in the context of a workplace. One thing you have to remember, though, is just because you got a rule and you put it in a policy, it doesn't mean you're going to meet your obligation for family status accommodation. All right? It also doesn't mean that you have to let the union off the hook. They're also a part of this problem and a part of the solution. So if a union says, look, that's your problem, employer, and you say we can give them another shift, and they refuse to to not grieve that placement on another shift, if it's appropriate, they are not part of that solution. All right? So we can actually put pressure on the union to do their duty as well. So when you're looking at this, and I just recently with a longtime client of mine, we got one from an individual who has child care responsibilities, and they got a lawyer to write a letter indicating that the doctor said the child needs certain accommodation. So think about how removed that is. And that's not okay, quite frankly. So what you do is you explore. What have they done? What have they tried? Have you looked at alternative arrangements? Have they looked at alternative arrangements? All right. Are there alternate shifts? Right? Can you consider a program that would assist them in looking for services in that area, which could assist them in meeting their regular obligations without an accommodation or with a slightly modified work schedule? All right? Look at interim scheduling while you look into this. So don't just say either show up for work or you're fired. Say, look, for the interim, we're going to do this while we explore this for the next couple of weeks, and then we'll come up with a solution. All right? And at the end of the day, ask the right questions about what the employee needs to be accommodated. And here we move over to the context of somebody who's trying to manipulate the system to somebody who requires legitimate accommodation. I know we have real issues with somebody who's trying to manipulate the system and saying, I want this shift off because my kid needs it off, or I have elder care responsibilities. That doesn't mean it's not a legitimate accommodation request. It means you have to do a little bit more research into it. So if you don't, though, here's the downside, all right? There are higher rates of illness and absenteeism when you've got the sandwich generation, all right? People are stressed. They're trying to get things done. Legitimate accommodation requests should be taken seriously, all right? And what we also find is that if you find people who are leaving the market as a result of these responsibilities, you're losing talent, you're losing experience. You've got to recruit again and put somebody junior into a position, or pay more money to get somebody that you already had doing the job if you could accommodate them. So let's separate performance issues and people who we think are trying to scam the system with legitimate accommodation requests, but look at them all and do a triage to see what's good and what's not, and ask the right questions before you say no outright. All right? Do them all, treat them all the same, treat them all fairly. That's going to sift through a lot of the issues. All right? So that's a big topic. We know there are lots of questions on this. We know you're getting these requests every day, but let's just really be let's be practical, and let's be very, very disciplined about how they're dealt with. We're going to move on now to social media. Megan, this is social media in the workplace.
Thanks, Lorenzo. We all know what social media is. I mean, there's no one clear definition, but it's essentially platforms or online tools that allow people to connect with each other. So think Twitter, Facebook, Snapchat, Instagram, anything like that. And the statistics on this are pretty interesting. I mean, you've got two sort of types of users. One, millennials who've never grown up with anything but the internet, who view email as old-fashioned and don't use that as a, normal means of communication. They use other platforms. And then you have, even the generation of boomers, people getting on social media for the first time. I think the statistics on the amount of users actively and regularly using Facebook are much more in the older generation, so to speak, in terms of the change there being, the percentage of users on Facebook. So this also impacts the workplace. With the advent of smartphones and all of these platforms on your smartphone, there's a lot of things that come in play. You can see here, interruptions in the workplace, people checking their phones, checking updates, too much information shared, employees befriending each other on these various social platforms, seeing pictures of their home life, seeing what they're doing on the weekend, just learning a lot more about, your coworkers or your boss or, your subordinate than you would on a normal, regular basis. And so this really does bring you sort of outside the four corners of the office. So some things that this raises, really, one is issues of privacy. What's fair game here? How do you deal with this? A lot of employers have put in place social media policies in the workplace that provides clarity and guidance on this. One thing especially, too, is even considerations of your employee using their social media and whether they reference the fact that they're an employee of your company there, whether that's permissible or you want that. You have to deal with that and address it in your policies. Because, this also raises a whole host of issues of improper social media use. Using it for improper, solicitation or selling of items, disparaging others online, threatening people, anything like that, which when linked with the employer can really hurt their brand. So this brings us into the realm of employee misconduct, and it's really misconduct sort of outside the normal four corners of the office, but it still impacts the workplace. If you have tweets or blogs that breach your harassment policies, it becomes a workplace issue. If you have people that bully, harass, intimidate, post pictures, anything like that, even though it's on their own time or outside the workplace, you're still within the four corners of the workplace and you have to deal with it appropriately. So what do you have to do as an employer? Obligations. Have a solid employment harassment and discrimination policy in place. Make specific reference to social media and what uses are acceptable both in the workplace and outside of the workplace. Also, if you even have an internal social media account through your workplace, you want prescriptions and guidelines about how it's used by your employees. So, to sum up, it's, an employee is obviously free to do whatever they want on their free time. However, this can't pose a threat to the employer's business interests, and it can't harass, bully, or intimidate other members of their work team. So it definitely poses a lot of problems and intricacies that employers really need to be aware about.
Yep, Michael?
So I'm going to take you through a couple of cases that sort of highlight this, and some of these are sort of well known. The first one is the Toronto firefighters case in Twitter. Now, this is an indication of the employees thinking that their accounts were somewhat private and that it was a defense to say no one complained initially about their tweets, which were clearly offensive on its face, and where they had indicated that, well, all we were doing was repeating popular statements made in some sitcoms or memes on the internet. Even though the firefighters were not tweeting in their official capacity as City of Toronto accounts, it did not matter. They had been publicly identified as City of Toronto firefighters, and therefore the image that was portrayed within the tweets was now transferring over to the image of firefighting services. A couple of employees were terminated. Another couple were actually suspended. Ultimately, the arbitrator who heard the termination grievance upheld the City of Toronto's decision to terminate the firefighters' employment. This was important because of two things. One, the arbitrator herself focused on the comments and how it affected the City of Toronto's reputation. Not only the City of Toronto's reputation, but the ability of the employee to perform their duties. And it was sort of a double-edged sword here. Both of these are important factors when considering obligations of the employee and what an employer can do. In this context, the arbitrator determined that the employee could no longer perform their job. She concluded that the conduct has harmed the reputation of the employer and impaired his ability to fulfill a complete range of responsibilities of a firefighter. It was a serious violation of human rights, anti-harassment policy, and injurious to the general reputation of the Toronto Fire Service. In particular, a fire service that was working diligently to try to attract female candidates. Clearly, this was not consistent with that approach. And this is identified in two other cases that are not here, but I think are also well known. One is the beer-throwing Blue Jay fan, and the other is the Hydro One TFC commentator. In one case, the beer-throwing Blue Jay fan ultimately was terminated, and that termination was not challenged by the employee. In particular, because his job as part of his duties was that he was a sports commentator. And so clearly he was identified and could no longer perform his duties, that his reputation impacted both his own ability to perform his duties and reacted negatively on his employer. Contrast that with the Hydro One TFC commentator who made explosive comments on a live broadcast while being interviewed. Ultimately, he was quietly reinstated even though he was initially terminated. Chief among the reasons was he did not identify himself as a Hydro One employee. He was outed by the company itself after they identified him. So he did nothing to overtly indicate that he was a Hydro One employee or was acting in any way representative of Hydro One. And the fact that he was outed by Hydro One themselves is what led to potentially a bad reputation. So for employers, be careful when you're identifying individuals. Be aware of the public publicity. Take appropriate steps where necessary, but don't create a situation that doesn't need to be blown up. Fiona's going to take us through a case regarding what employer obligations are with respect to their own internet obligations.
Yeah, thank you, Michael. So in this case, the TTC had a Twitter account, which was created by the TTC to respond to customer service questions and concerns. In 2013, the TTC's union became aware of online abuse and harassment by the general public directed towards TTC employees through this Twitter account. Users were making comments about TTC employees that were, quite despicable. They were racist, sexist, homophobic, and actually violent. The arbitrator determined that the TTC had failed to take all reasonable and practical measures to protect its employees from harassment through the Twitter account. So what's important from this decision is that the TTC's Twitter account was part of their workplace, and employers have a reciprocal duty to their employees in administering their online accounts. Michael and I were actually considering a very similar situation for one of our employer clients just last week. In terms of what employers can do to prevent this type of decision, we suggest that employers have a policy in place that specifically says if a member of the general public makes an inappropriate comment on the social media account, it will be immediately removed and that member of the general public will be blocked from making additional comments. Employers should offer support to employees whose duties are to respond and follow these social media accounts. If it persists, employers can consider, and employees aren't coming forward with issues of harassment, perhaps they're embarrassed to make the complaints to their employer, employers can consider doing a random audit to see what sort of messages their employees are being subjected to. And in addition, if the comments really are quite bad, employers can also consider outsourcing these duties to a third party.
Thanks, Fiona. And remember that just because an employee is involved in something, in a social media issue, it doesn't mean you necessarily have cause to either discipline or terminate. There's an interesting case that was just released with respect to a former Maple Leaf who had a contract to do certain advertising for a certain company. His girlfriend had made available certain pictures that they had exchanged with each other, and the courts found that that wasn't a morals issue because, number one, she had released it, not him, and secondly, that they had actually gotten the services that they required before the information came out. So you have to look at these things objectively, and you have to make sure that you look at a reasoned approach as to how you're going to deal with the employee. That'll put you in a better position in terms of dealing with them in the future. So we're going to move off social media and we're going to go to departing employees. Michael and I just yesterday were dealing with an issue with respect to an employee who had departed and has been accused of solicitation, and we're dealing with an injunction. These things get heated really quickly and are quite expensive and quite difficult, but employers have a legitimate right to protect their brand. So let's talk about how they do that. Restrictive covenants. It means a covenant being something that is in an employment agreement or a document which is binding between the parties and says you can't do this at this time for this period of time. That's as simple as we can put it. And what it does is the ones that you're most commonly hear of are restrictive covenants concerning non-competition and non-solicitation. All right? Now, very difficult to explain and very difficult to enforce. The bottom line is that, and I'll move on to another one, there's also other ones, intellectual property covenants, which deal with how the employee can deal with intellectual property following the termination of the employment relationship for any reason, and the protection of confidential information. Those are much more kind of generic and apple pie restrictions that the courts are more willing to enforce. So the bottom line is this, that when we've got issues concerning employees who are leaving, employers generally now have provisions in employment agreements which says, here are your obligations, both with respect to non-disclosure, which is usually a very long following the termination of employment, non-competition, non-solicitation, intellectual property. Non-competition provisions are considered in Canada for the most part, and the law gets very complicated, but prohibitively to be kind of presumptively unenforceable, but they can be made enforceable in certain circumstances. Reasonableness is the guideline in many cases. Michael's going to take us through a little bit of the issues with respect to enforceability.
Thank you, Lorenzo. So when it comes to enforceability of restrictive covenants, clearly everyone who's dealt with these understands that in Canada and Ontario specifically, it's really difficult to enforce, in that Canadian courts usually take the approach that prohibiting an employee from continuing in their employment elsewhere is either going to be considered a restraint on trade, that is, the courts don't want to see competition hindered amongst companies generally, because that's bad for public policy, it's bad for the public. Also, they take a high regard with respect to employment itself, with respect to the self-worth of an employee who they do not want to see sitting on the sidelines for an extended period of time, allowing their skills to deteriorate. It is a situation in which, when it comes to non-competition, employers should be using a scalpel, not a hammer. So identify the individuals who are the most, dangerous, I suppose, in a certain sense of risk if they move to a competitor. Focus on those individuals. You do not necessarily need or maybe ever need a receptionist to have a non-competition arrangement, but maybe clearly you need your sales force or other senior managers. When it comes to salespeople in particular, a non-solicitation clause is often considered by courts to be sufficient. And therefore, if you can get away with just a non-solicitation clause, the courts will not enforce a non-competition. They will not allow overreach. And so when it comes to assessing reasonableness, keep the duration as short as possible. Quite frankly, anything more than a year is highly dubious. You want to keep within 3 to 6 months. Geographic scope, keep it as narrow as possible. Oftentimes look at the employee. Where is the employee likely to move to? Are they likely to move to Europe to work? If they're not, you can narrow your geographic scope considerably and get your benefits of enforcement. And limit the scope of activity. Define your business. What's the area that you want to prevent them in? If it's any business that's competitive with the company and anything it might do in the future, that kind of vagueness is going to lead courts to say that they're going to strike the clause, and if they strike the clause, they strike the entire thing. When it comes to confidentiality and non-disclosure agreements, these are much better and much more enforced. Courts do respect proprietary information in companies and expect employees who leave to keep that information confidential. You're still best served with a written contract. However, there is an implied duty of good faith which prevents employees from disclosing confidentiality. Oftentimes that scope of duty is reduced following employment. It is limited to only what's necessary to protect the interests of the former employer. So it's best when you're talking about protecting trade secrets to spell out what you're talking about with respect to a departing employee and what their obligations of confidentiality are. You've got this great safety net, but in this case, particularization can help you. It will also help you with respect to explaining to a court why disclosure of that information is particularly problematic and dangerous or harmful to your company. And in fact, Megan will talk about broader duties, fiduciary duties of some senior employees.
Thanks, Michael. Yeah, a fiduciary is a person who holds a legal or ethical relationship of trust. So in the employment context, a fiduciary employee is really one that an employer trusts and gives a high measure of responsibility. So think officers, directors, senior employees, VPs, executives. These individuals, on leaving a company, would be prevented from using confidential information due to this fiduciary relationship. This could also apply to even non-executive type employees where that individual has a scope, a wide degree or discretion of power, that they can unilaterally exercise that power or discretion so as to affect the employer's interests, and that the employer is, somewhat vulnerable or at the mercy of that person in that role. So that's something else to remember and think about when you have a departing employee. What was their position in the company and whether they owed any kind of fiduciary duties to the company? Now, generally in terms of legal remedies, what do you do when someone leaves and they start soliciting people or breaching any of their obligations to the company? So number one, look at the restrictive covenant, determine if it's valid. If so, an injunction is likely the best remedy. Injunction is different than damages. It's really seeking on a very quick basis an order from a court restraining that person from continuing in that activity. So you're not suing for the monetary loss that the company suffered. You're moving for an order restraining that person from undertaking that activity. Here's some points on it too. It's a discretionary remedy, so courts will limit it to what they consider is reasonable. They won't give a carte blanche order that would impact potentially impact someone's ability to make a living. And this is due to the fact from a policy rationale that, free competition is widely valued. Anything that's viewed to be a restraint on trade and the ability to learn a livelihood is a factor that courts will consider. So there really must be strong evidence that the company will suffer irreparably from the nature of the conduct at issue.
So just to be clear, you can't get an injunction if damages would suffice, okay? Damages may be part ultimately of a trial following an injunction, which is called an interlocutory remedy, which means prior to trial, but it usually settles the matter. So the distinction is this. If you can prove that the solicitation of an employee is creating damage, monetary damage to your business, all right, that is something that you might consider as a lawsuit for damages for their breach of their non-solicitation provision in their employment agreement or their fiduciary obligations at law. But if their breach, for example, if they are moving and there is a concern of them using or divulging confidential secrets, intellectual property, or the damage can be so great that it cannot be compensated in damages or cause what we call irreparable harm, that is an injunction application. All right, and they are very rare and they're difficult to get. They're as expensive as hell, and they require a lot of vigilance and a lot of work to get them. All right, so when we see departing employees who are in breach and are about to move to another company where they can do some real damage, not just compensated in damages, but to the business itself, that's when an injunction is appropriate. If it's just monetary, you got to stick to a lawsuit, or the court's going to say, thanks for spending the $50,000 on the injunction, we're not going to give it to you, you can sue. And it might even be a little higher, right? So when we're talking about what you can do and what the remedies are, remember that an employee doesn't say, just because I'm terminated, I don't have any obligations, particularly when it becomes an issue of fiduciary obligations or confidentiality. You still can't disclose confidential information just because you're terminated. That is confidential. You can't say it, period. All right? And the courts are going to look at things like, how bad is the conduct? How outrageous is it? Is it a technical issue? And it's not only whether the employee is trying to have their cake and eat it too, that is, move on, try to get a new job, get business, but also what's the legitimate remedy that the employer requires to protect their interests? Sometimes, I always say this to employers, how long do you need to get a head start if this employee leaves from a non-solicitation provision? So oftentimes it's 6 months that they can't go out and solicit. You're a company, you got a 6-month head start, you should be able to pull that off. Sometimes, a 12-month non-solicitation is also very reasonable in the circumstances. So we're going to look at a couple of cases that demonstrate this. Fiona's going to talk about the Wisniewski case. Fiona?
Thanks, Lorenzo. In this case, 2 employees had worked for their employer for 8 and 10 years, respectively. Their employment contracts contained well-drafted non-solicits. The employees left work for a competitor, called their former clients, and invited them to follow to new business. The employer discovered the actions of the former employees and commenced an action to enforce the non-solicit agreements. Both at trial and at the Court of Appeal, the courts agreed with the employer. The employees had argued that the non-solicits were overly broad, vague, and unfairly restrictive, which are the standard arguments that are applied. But the courts disagreed and said that the non-solicit was reasonable and it was enforceable. So this is a very positive decision for employers, that if you take the time to draft a reasonable and properly worded and clear non-solicit, there's a very real chance a court will enforce it.
Yeah, and look at the facts in here. They left to work for a competitor, called their former clients, and invited them to follow to the new business. That sounds to me pretty much like a solicitation. It gets a little trickier when you deal with things like posting on Facebook that you're at a new job, or LinkedIn, that you've gone to a new job. There are some UK decisions that talk about LinkedIn, but generally the kind of information that you're leaving to go to a new employer is not a direct solicitation, although in certain circumstances it can be.
It can be. And if you're inviting a specific group of people, or your Twitter blast is to your former clients to the exclusion of everyone else, the court can infer that was a solicitation to those particular clients. So in these situations, if you're on the opposite end, if you're the employee, have a blast that goes out public, have a newswire, have a public announcement that you're starting with your new organization, and no other information other than your contact information. If your former clients contact you, that's not a solicitation.
And remember, too, that these are difficult cases to make, Because quite frankly, if you are suing an employee or trying to get an injunction for an employee for soliciting clients, oftentimes the information you have is that the clients are dealing with that new employee. So you're going to have to put the client in between you and the other employee to prove your damages. If they've already contacted them or already dealing with them, they may not be real happy about testifying with that information. As a matter of fact, they may have already decided to move over or are thinking about it. And you saying, guess what, I'm going to make you a witness in this trial, is not such a great way to keep the client. So you got to take a measured approach. Think about that before you go off and say, we need an injunction, we need to sue them right away. Megan, let's deal with the costlow case.
Thanks. Yeah, this case raises a lot of the issues we've just discussed, and it's a warning for employers in terms of dealing with a departed employee. In this case, the employee was an engineer who worked for an engineering firm for a number of years, and he was eventually promoted to the position of vice president of supply chain. So in this role as vice president, he was provided with a large number of common shares, and he was, under that, he was expected to receive 10 different installation payments for those shares. So the employee received the first payment, and then he resigned, and he went over to another competitor company and took on the position of CEO with a rival firm. So at this departure, the former employer was not happy and alleged that it didn't have to pay any more of the shares to Mr. Costlow because he had violated his fiduciary duties to the company. In particular, the company alleged that he had solicited employees, and so therefore they used that as the justification not to pay out the remaining shares. So Costlow sued his former employer, alleging breach of contract, and sought really the remainder of the 9 remaining installation payments. The company defended on the basis, arguing that the former employee had breached his fiduciary duties, so therefore they were entitled to set off for those installation payments. In particular, the company alleged that Costlow had breached his duties by enticing former employees to leave their employment and by using confidential information. Now, when the court heard all the evidence, at the end of the day, it found that the employee had actually not solicited or breached any kind of fiduciary duties. Actually, other employees had come and reached out to him. So the company was not successful in this case and actually ended up having to pay a big chunk of the remaining installation payments. Great.
Thanks very much. So that's our issue on kind of restrictive covenants and how they can be interpreted. And I think you've heard some very practical advice on how to address these and get some legal advice before you kind of move forward. We want to move now to our final topic on gender issues and harassment. The media, it's not only the media, but it's an issue with respect to a changing and an evolution of attitudes at work with respect to harassment and bullying and violence in the workplace, which is a welcome evolution, but it does create issues for employers in terms of how to deal with it. We're going to take you through a little bit just about the law, and we'll go through that fairly quickly, but also about applications in the workplace, because there are actually going to be issues of trying to find out factually what is where and how you deal with them. Michael?
Yeah, so with respect to the legislative protections, it's found under the Human Rights Code and in the Occupational Health and Safety Act. Both legislative regimes provide an obligation to employers to prevent and protect all employees, clients, and contractors from harassment, discrimination, and violence. It's actually to protect the workplace, both those people who are working for you and those who are invited into your workspace. It's to protect employees from harassment, including sexual harassment, which is particularly defined in this legislation. And finally, to provide procedures for complaint, investigation, and resolution. That's really the process mechanism to identifying complaints, identifying harassers, investigating, and ultimately coming to a conclusion of the resolution, which could include termination of employment. Harassment itself has got a broad definition. It's any course of vexatious comment or conduct that is known or ought reasonably be known to be unwelcome based on one of the prohibited grounds. Translation. First off, you've got to do something. It's an action-oriented prohibition. That is, the individual should be acting in some concert that disturbs or annoys or distresses another person. It is very much a subjective approach. That is, am I being annoyed? Am I being distressed? Am I being affected by the content or comments or conduct of another individual? And it's something, here's the objective situation. Should the other person have known, or did they know, that those comments and actions were going to be distressful, and they did it anyways? Key here is that societal changes can impact or affect what should be known or individuals ought to know is to be wrong. That can change over time. It's no defense to an individual saying, well, I made this comment or displayed this picture 5 years ago, and no one had a concern with it. Why am I being challenged now? That is because society has changed, and what you ought to have known as improper has changed itself. When it comes to sexual harassment, clearly there's a sexual component to this. So it is one that's related to sexual orientation, gender identity, or gender expression. Again, it's not just the identity or individual of the employee themselves. It could be their perceived sexual identity and sexual orientation, or it could be one that is clearly contrary to them but is being used in a hurtful manner. So really it's a combination of both the conduct and the individual themselves and how they identify. As far as elements of harassment, Megan, you can take us through that quickly.
Thank you. Yeah. I mean, harassment can be verbal, physical, or visual. The criteria is really whether a reasonable person in the shoes of the victim would be offended. So, you know, in terms of this, the comment or conduct doesn't in itself have to be intentional. It could be accidental, but it still the question is whether a reasonable person would be offended. So, you know, it's not limited to just one conduct or multiple conducts. It's really situational. It could be, you know, one incident where it's serious or egregious enough to constitute a threat, or it might be a series of comments or conduct that add up to be that. Also, the victim does not have to object to the behavior at the time to establish that harassment took place. So there's also a concept in law called the poisoned work environment. This is where, you know, comments or conduct that tend to ridicule or disparage a group or cause humiliation or, you know, apprehension or concern creates what's called a poisoned work environment. So it doesn't have to be directed at one specific person. It can be more broad in general, but it creates such an environment that individuals or an individual feel uncomfortable in place. Now, Michael's covered elements of sexual harassment, but here's some more you know, examples that really highlight what can go on in the workplace. Posting or texting inappropriate material, sending any kind of joke email that would reasonably offend someone receiving it. So, you know, if it has a sexual tone or remark to it. Touching another employee in a way that you know is not welcome. Asking another employee for something sexual or romantic in return for a favor, or threatening an employee if they don't respond to sexual advances.
Fiona?
Yeah. So as Michael set out, under both the Ontario Human Rights Code and the Ontario Health and Safety Act, employers must maintain a harassment and discrimination-free environment. This duty extends to off-site events. So where is the workplace? Harassment can take place in the workplace itself or outside the workplace in situations that are in some way connected to work, such as off-site meetings, business trips, social gatherings, end-of-year parties, and really any other employer-sponsored event. And as we discussed earlier, certainly social media.
That's a really good point, because on social media can expand the workplace in the sense that we saw in the transit decision as well, that if the employer understands this and knows about it and does nothing about it, there might be actually liability on the employer in some sense. So how do you meet the duty? Well, you know this. You're all sophisticated enough to understand that you need good policies in place, and you have to those policies have to have an avenue for an investigation, which, by the way, should include a process whereby if the person's own supervisor is the one who's going to take the complaint and they are alleged to be the harasser, that there's a manner in which to make a complaint outside of that individual. You got to be prompt. You got to be confidential to the extent that you can. You can't promise in an investigation absolute confidentiality all the time, because you're going to be interviewing people. You have to look at the circumstance. You have to determine whether there's going to be an investigation and what that investigation is going to look like. Is it going to be from an objective third party? Is it going to be internal? All of these things have to be done to ensure that you're meeting your obligations with respect to harassment in the workplace. Make sure that you've got regular training. Make sure that employees sign off on that regular training. If you've got policies in an intranet, make sure that that employees can sign in and sign out to show that they've reviewed them. So a big part of this is not only demonstrating and saying that you've got it, but actually proving that you've done the hard work in terms of making the employees understand exactly what they're going to be required to do. We know that you cannot retaliate. There can be no threats or reprisals as a result of any complaint. Here is and all of the legislation protects, both in occupational health and safety and in human rights, it protects the employee against reprisals for making a complaint. All right? And then it turns to the employer to explain and to prove on a reverse onus that they didn't do it, so they're proving a negative. Now, the real issue for employers out there is that they'll often get a performance management, and then you'll get a complaint of harassment or bullying as a result of that performance management, and then the employee says that any conduct as a result of that performance management is a reprisal. If you have good policies and you stick to your workplace assessment and performance reviews, you can defend against these, but you've got to have the documents and it's got to be on file. And understand that this is a serious issue. The courts are not going to give you a break. If you did something wrong, they're going to find out. All right? That means that you make sure that you've got your training, that everybody understands that it's all of our responsibility, that you can show that you've assessed the issue and issued discipline where necessary. All right? If you don't, you're going to be facing a human rights tribunal matter or a wrongful dismissal for constructive dismissal in a poisoned work environment, which can incorporate human rights issues, or a health and safety complaint that it's an unsafe work environment. So very, very important. And Michael's going to go through a couple cases which talk about this.
Well, I'd like to just identify two of the cases that speak to this issue, Doyle and Zouk and Boucher and Walmart. I think the key takeaway from both these cases are, one, it identifies employer obligations with respect to conducting an investigation and going through the process. In both cases, the companies fall well short of their obligations to investigate and then come to a conclusion and issue discipline. Secondly, the takeaway should be look at the numbers. We're now into six-figure damages territory. These numbers will only go up, particularly because the Ontario Court of Appeal is now getting comfortable with these numbers. It's no longer a situation in which you can wait for appeal to have the numbers reduced. Trial judges and the courts are getting comfortable with these kind of six-figure results. It's not going to get to a U.S.-style punitive damages award, but clearly the numbers are going up, and this is a bottom-line cost to your company if you fail to investigate.
So Fiona's going to talk a little bit about alternative work arrangements, then we'll have a little bit of time. It's a big topic today to take some questions. Fiona?
Mm-hmm. Employers are increasingly considering various forms of alternate work arrangements in connection with accommodation issues. Some of these that we've seen our employer clients consider and implement are flex time, job sharing, and permitting employees to work from a home office. Each of these has benefits. For example, with flex time, employees have more control. We certainly encourage employers to establish a policy regarding this. Employees can trade off certain benefits, for example, lieu time. Many of our clients are also offering compressed work schedules, maintaining an overall time commitment. However, there need not necessarily be an impact on production, performance, or compensation requirements. As well, job sharing. The issue with this is it does increase the number of overall employees. Additional forms of alternate work arrangements, working from the home office. So from an employee's perspective, they avoid commute times. It allows for work and home life scheduling. Open office, it can reduce overhead costs. You know, as a result, if you're paying very expensive rent, it may be great to be able to have additional employees, but not necessarily taking up office space. And it can, you know, depending on the circumstances, influence greater or maintained production and or efficiency.
Megan?
So before you enter into these kinds of work arrangements, you should also still consider some of the downsides as well. And we've listed a few of them here for you. You know, there can be some negative impacts as well. The employee working from home can feel isolated. They can be outside the work culture, miss what's happening in the workplace, and be really separate and alone out there. They can also be difficult to manage and supervise. How do you know what's going on? How do you know that work is getting performed? How do you interact with them and check in and monitor? The other impacts on production and efficiency. Working at home can lead to further distractions. Time off, downtime, social media, as we described. Also, impacts on on teamwork and morale. Consider that, whether it shows favoritism in allowing certain employees the ability to work from home versus non-employees. You often hear this the most with employees with, ones that have kids versus that don't have kids, and the sense of favoritism that comes out of that. So be careful and think very carefully about it before kind of arranging these types of arrangements. The other point too is just in terms of reintegration. How do you then bring someone back into the workplace that's been separate and apart for so long? And then finally, on the point of home offices, this raises a whole host of other issues too. If you're providing these kind of arrangements, you're going to have to factor in the cost. Are you going to provide for the necessary hard equipment, soft equipment for the employee to work from home? Are you concerned about privacy or confidentiality? Are you going to require shredding? Is their home server going to deal with workplace emails? What are you going to do about the security of confidential information? And a whole host of other issues too in terms of workers' compensation and occupational health and safety. How do you track and monitor their hours of work? Yes, I raised the fact earlier they might not be working enough, but what if they're working too much? How do you know that they're not working and raising claims of overtime issues with you? So a whole host of considerations to really think about and consider. A lot of pros, but some cons as well that you should really consider carefully.
Great, thanks, Megan. And just finally, then, in our last slide, if you're going to do this, the importance of having a document which sets out exactly what is expected of an alternative work arrangement, and that can include things like we can recall you to a regular work environment, so there's no constructive dismissal issues. We're going to have on-site meetings or perform what we may want to inspect. If you're going to do workers' comp, how do you deal with that? Well, you might want to put a provision that says that you're going to have one room in your house which is dedicated to that, and that way, if you go outside and slip and fall, get in the paper, that's not a workplace accident. It really does highlight the importance of having a document which puts a fence around exactly what this relationship looks like. Otherwise, you could run into problems if you just kind of pull it back. And you're going to have to figure out a way to supervise. You got to monitor performance. You have to bring it to their attention. All right? So all of these things together will inform your decision as to whether or not an alternative work arrangement works. A couple of questions real quick. Michael, do you have one you want to answer?
Yeah, there's a couple of questions that have come in, a number of questions. We can get to a couple of them. One is someone asks, what happens if you've got an injured worker who's being accommodated but is on Facebook doing all sorts of activities that appear outside their restrictions? First, Facebook is not private. It is public, even if privacy settings are on. So as an employer, you're entitled to rely upon that information and make inquiry as to what you consider to be some kind of dislocation or some kind of conflict with the information you have. Our only recommendation is that you don't get out over your skis with respect to assuming that because the person appears to be working outside the restrictions, it's actually going to work. It's very difficult to prove. The employee who is on leave still is entitled to go on vacation, and the vacation can include going to the beach and maybe doing some activities. What you won't hear is the fact that the employee said, yeah, I tried this because my doctor said I should try to engage in some activities, and the next day I was totally laid up and back in traction, and I won't be doing that again. So just be careful. Don't jump to conclusions. Another question is, do you recommend employers performing routine monitoring of public Twitter accounts of your employees and Instagram? Short answer is no. I think that's going to take way too much time. You might also find out answers to questions you don't want to ask and don't want to know. The more important takeaway is that if it comes to your attention or complaints are raised, it's not a response from the employer to say, well, that's a private account or that's a private communication. Clearly, if one employee is complaining about it, it's no longer private and you have a duty to inquire.
Good. Thank you, Michael. One final question. It says, can a doctor determine when an employee can work on an accommodation request? So look, a doctor can only provide restrictions once they understand what the duties are of the employee. A big mistake we see employers all the time is they ask for medical information supporting restrictions and accommodation, but they don't insist that the doctor understand what the job duties are. A doctor can provide restrictions, all right? You have to assess procedurally and substantively whether or not that accommodation is appropriate. So doctors can only provide information. You must make that decision as an employer. Okay, so that is our presentation for today. We'd like to thank you for joining us. That was kind of jam-packed, but a lot of information. I want to bring a couple things to your attention. Our next webinar is on occupational health and safety. That is on Tuesday, May the 14th. You're going to get a follow-up on that. And on the side panel that you'll see, we're providing you with an opportunity to win a complimentary pass to the Partners in Prevention, where a number of us will be speaking. Click the link to submit the entry, and don't forget to vote for the 2019 Canadian Occupational Safety Reader's Choice Awards. We are up for those awards. We hope you vote for us. So again, thank you all on behalf of Michael, Fiona, and Megan, and we look forward to you joining us for our next webinar. Bye-bye.